Yes, Mr. Farrell.
Good morning. So I will deal with condition B. In some respects, there's now little between the parties on how the condition should be construed, and certainly less than there was. But there are also aspects where that apparent agreement hides deeper disagreements. So we do need to look at this in some detail. And of course, there's a gulf between us on the application of the condition in this case, in light of the FTT's findings. Some introductory points. As Mr. Kirby said yesterday, these rules are not pure anti-avoidance. They're levelling the playing field. They're of wider application than to fruit pickers who are made members of LLPs or whatever the slightly absurd extreme case was. Then we've got the three conditions A, B, and C are clearly chosen as reflecting important factors that would be taken into account, amongst others, in assessing whether a person was an employee or a partner for what we're calling common law purposes. No single factor is determinative at common law, and we don't say that the three statutory factors, the three conditions, either individually or collectively, establish a perfect reflection of the results of the application of the common law, and not a perfect proxy. One should not expect a partner to fail every condition, and there may be true partners, people who would be assessed as partners under the common law test, who meet every condition and are taxed as employees. That's inevitable because the common law and the tax statutory approaches are different. But as explained by Mr. Kirby yesterday, each of the condition reflects a relevant factor, and in our submission, each should therefore be construed in light of the case law dealing with that relevant factor. So they're not perfect, they're not exact mirrors, there are differences. First, each of the conditions, this is now common ground as I understand it, is applied prospectively, so that one can assess at the start of the relevant period whether a given individual is to be taxed as a partner or employee. If an employee, they'll have a PAYE coding and so forth. Whereas the common law tests are clearly applied with the benefit of hindsight. Secondly, each condition introduces a threshold or hurdle that's not present in the relevant common law factor. For conditions A and C, the hurdle is clear and quantifiable. There has to be a certain level of profit sharing, capital contribution, not just any level of profit sharing or contribution. For condition B, necessarily given the nature of the test, the hurdle is less hard-edged. The requirement is significant influence over the affairs of the partnership, rather than any level of participation in management of the partnership. You see, that is another common thread between the three conditions and informs the construction of each. The hurdles make sense in the context of a test that effectively requires just one factor to be present, as opposed to one that assesses a full range of factors. And turning to the common ground. First, this is condition B. Condition B is looking at influence that's given by mutual rights and duties, meaning legally enforceable rights derived ultimately from the LLP agreement and statute, but including implied terms, equitable obligations, equitable rights that accrue to members.
Sorry, Mr. Vella, could you keep your voice up?
Sorry. Sorry.
That's not an amplifier.
Okay. Right. So mutually enforceable legal rights derived ultimately from the LLP agreement and statute, but including implied terms and any equitable rights that accrue to members. That also includes rights conferred on members by virtue of their appointments to specific roles in the LLP, even if those aren't set out in the LLP agreement. We would say that that is essentially the same as what the Court of Appeal called qualifying influence. It's true that the Court of Appeal did not mention that rights might derive from specific appointments, but there's no reason to think the Court would have disagreed with that had the point been put to it.
Well, it might be said that the reference to the entire agreement clause in 25.1 suggests they did exclude that.
well, maybe, but the point wasn't put. We say it's an obvious one that follows from the logic of accepting mutually enforceable rights and obligations, and to say, for the court to say that, for example, a managing partner who's appointed to that role and given a clearly significant role in directing the strategy of the firm wouldn't have significant influence because the rights derived from a role, not directly from the LLP agreement, would be an odd conclusion, and one that I think we should be slow to attribute to the Court of Appeal. The jobs that are working out of the rights under the LLP agreement, they're not at odds with the LLP agreement. They don't require a modification of the LLP agreement. We would say there's no reason to think the court would disagree with it. It's the working through of the court's reasoning, we would say. And it's a point that could be made by BlueCrest on the remitter, that those rights are included within qualifying influence.
But these points simply weren't explored before.
They weren't explored. And again, as my learned friend said, one can see why, because until we got to halfway through the Court of Appeal hearing, we were all proceeding on the basis that de facto was enough, and we were shown the light by Lord Justice Henderson, and that's why probably the points weren't fully developed as they have been since. And that's why there's now significantly more common ground between us. We've all had a chance to reflect on and work through the implications of what was said, and we've come closer together. Now, so that's qualifying influence, in effect. A slightly extended version, maybe, but we say entirely consistent with what was said in the Court of Appeal. Now, on the other side, influence derived from other sources does not count, whether that influence is freestanding or wholly extrinsic, or additional influence enjoyed by a person by virtue of extrinsic factors. So my learned friend gave the example of the junior partner who's unusually persuasive or charming. The additional influence above and beyond that derived from their role as a junior partner is ignored. We accept, of course, that that doesn't mean that the influence derived from the role is ignored. It's just the additional influence that's ignored. It doesn't matter what that other source is, whether it's personal qualities, relationship to a senior partner, the son of a managing partner, etc. We're just focusing on the legally enforceable rights that give influence, not on personal qualities and so on that might also give influence.
So you would accept, I think, the appointment of a person to manage a 100 million portfolio is of itself part of his role.
Yes.
Can be relied upon. Whether he does it well or badly is neither here nor there.
Sorry, I'd accept it's part of his role. I wouldn't accept that those rights amount to significant influence over the affairs.
No. I'm looking
yes,
to see whether it's a source from which influence could be derived.
Yes,
whether
the appointment as
a
portfolio manager is a source from which influence might be derived.
Yeah.
And certainly, the appointment to a managing board, whether or not that board is expressly created under the LLP agreement, would clearly be a possible source of influence.
To a management board with delegated authority to act for the partnership.
Yes, whether or not it's expressly created under the LLP agreement. I mean, obviously here, the board is.
Yeah.
But, now, in relation to this, I also note that my learned friend has accepted that influence derived from performance is discounted, so that one does not take into account the extra weight that might be attached to the views of a particularly successful or profitable portfolio manager.
Well, these points are all consistent with the first point you made, which is that the condition has to be applied prospectively. You're not going to know how the PM is going to perform in his role or what extrinsic influence the PM is going to have. You need to be able to look at the position prospectively and say, is there or isn't there qualifying influence?
I completely agree. My second point is precisely that the test of perspective. On the first point, The final points I had on that were just in relation to the intervener's case. If we turn that up, the bundle, page 115, first of all, and just these are points of detail. The interveners refer to the position of a shadow member. This is paragraph 18 at the bottom of page 115. And say that the sort of influence enjoyed by a shadow member is the sort of influence that one might be looking at. We would say actually...
Sorry, what paragraph?
Paragraph 18 of the intervener's written case, bottom of page 115. We would say the problem with that is that a shadow member, their influence precisely can't derive from the mutual rights and obligations. It's in a sense the opposite. So I don't think anyone can derive any comfort from that, or that sheds any light on the proper approach to influence in this case. And then in the same case, in the same written case at paragraph 33, page 121 of the bundle, this is talking about the most important individual within a firm and the sort of influence that that person might have.
Sorry, which paragraph? I've missed that.
So it's paragraph 33 on page 121.
Oh, yes, thank
In
you.
practice, the most important individual within the firm may exercise soft power by virtue of their status, etc. Now, the problem with that is that the soft power described there is, again, precisely the sort of thing that is outside condition B, because it doesn't derive from the mutual rights and duties. The list status have found the level of investment, unless that's reflected in votes or something, but in itself level of investment, relationships within the firm, relationships with clients, and the ability to earn money for the firm, those are all extrinsic factors. So this is, again, an example that if it helps by showing what you don't take into account, not what you do take into account. So that was the first point. There's common ground with a little bit of amplification from me. The second point, which I appreciate the court already has, is that condition B is to be applied prospectively. One has to be able to assess whether a member fails the condition by looking at their rights, etc., not by looking at either their performance in the role or their exercise or failure to exercise the rights. Third, is again related, it's common ground that influence is not just impact. We say it requires the right in some form to contribute to decision-making. That's our position in any event. So a person does not have influence on the business merely because their performance of their role has a significant effect on the business, for better or worse. So that might be a profitable portfolio manager, has a beneficial effect. A loss-making portfolio manager, or I think we've talked elsewhere about a careless security guard, might have an unhelpful effect. But we're not interested in effect. We're interested in deliberate influence. I believe that's now common ground, because my learned friend accepted yesterday that the test was prospective, but also referred yesterday to financial influence as meaning not how well someone has done, but the financial extent of their role and responsibilities. So it's not the level of profit that someone earns for the firm, it's in this case, the capital at risk, capital allocation. Now that's important here, because we've seen and we'll see again that the FTT attached weight to the financial contributions portfolio managers made to the LLP profits. I think the court has in mind the reference to the 300 million over 10 years. That's in paragraph 194 of the FTT decision, bundle 217. I'll come back to that, so we don't need to turn this up now, but of course we could, if helpful. We'll leave that for later. Fourthly, both parties agree with the Court of Appeal that significant means more than insignificant and with commercial substance. I slightly, that means the word is almost meaningless, because I still don't understand why anyone would be taxed by reference to insignificant rights or rights without commercial substance, but in any event, that is significant, adds some intensity to influence. Now, it's not entirely clear whether the appellants agree with HMRC that significance must be relative, or at least assessed in the context of the business concerned, but we'd say it surely must be. It's important because, as Mr. Kirby demonstrated yesterday, even the limited rights to consultation enjoyed by the members under the LLP here are subject to the control of the board and or the corporate member that can always outvote the individual members. So it's one thing to say, oh, they have a vote in certain circumstances, but when you see that that vote can't be decisive, it obviously reduces the significance of that factor in any assessment. Similarly, it's not clear whether the appellant agrees with HMRC and the Court of Appeal that non-qualifying influence, i.e. derived from an extrinsic source, may affect the significance of the qualifying influence. That's in our written case, paragraph 70 at bundle 92, referring to the Court of Appeal, paragraph 94 at page 163. I say referring to, I don't think we've actually got the reference in the case, but that is where it's picked. That's where the point is made in the Court of Appeal judgment. So our case, paragraph 70, page 92, Court of Appeal, paragraph 94 at 163. Again, this is important here, not least because Mr. Platt, although not a member, clearly had considerable influence over each and every aspect of the affairs of the LLP. And that is on page 155 in the Court of Appeal, paragraph 69. We haven't gone through the facts, but the court will have in mind that Mr. Platt sits at the top of this structure. And I'll come back to his involvement later, but he is, as set out there, clearly an important figure. Fifthly, then, it's common ground that affairs is a broad term. It's now also seemingly common ground that condition B is asking whether the relevant member has significant influence over the affairs of the LLP generally, as opposed to over a single aspect of the affairs of the LLP. This is important because it was not common ground before the FTT, where the appellant argued, and the FTT accepted, that significant influence over an aspect of the LLP's affairs was sufficient. The conclusion is at FTT 178, bundle page 214, which I turned up at 3 o'clock yesterday.
Sorry, which paragraph?
It's paragraph 178 in the FTT at 214.
I don't quite. I'm having just a little bit of difficulty seeing how that is common ground, because, as I understand the appellant's argument, it's enough for them to have a significant influence in relation to, as it were, a significant part of the business, and that they say means they've got significant influence over the company's affairs.
Maybe I'd slightly. I mean, where I thought we'd got to is that the appellant was saying, yes, it's influence over the affairs generally, but that can be demonstrated by having sufficiently significant influence over
a part.
Yeah, but I think you end up in the same.
Yes.
So it's a different way of getting to significant influence over the whole.
I see.
But what I was starting with is just emphasising that that is not where we were before the FTT, and that is not the basis of the FTT's decision. Now, on that, if it's helpful, because we haven't really talked about the infrastructure services side of the business, it may be helpful just to look at page 178 of the bundle, paragraph 31 of the decision, which gives some figures for the fee income derived from different sources. There's a table. At the bottom of page 178, internal page 5, support service fees, those are the infrastructure services that, and you can see that the support service fees are 55, 23, 27, 23 million in the 4 years. The total investment fees are obviously larger, 93, 76, 104, 110. But the management fees for the investment side are very much in line with the support service fees, and it's the performance fees that make the difference. So the management fees are the ones that are fixed by reference to the amount being invested, and the performance fees are the ones that depend on how well the investments perform. We would say, that looking at the management fee, the fixed element is a better indication of the relative size of the operation. In any event.
Why do you say that?
Yeah.
Well, because that depends on how much you're managing, how much managing you're doing. The performance element is how well you happen to do out of your managing. But in any event, I don't want to get too bogged down.
No.
In any event, they're all large numbers. It's not a part of the business that you can just ignore.
Sorry, so I'm confused about what you're actually saying about this.
What I'm saying is that the infrastructure service side of the business is a significant part of the business.
Right.
I'm sorry, I was trying not to use the word significant, but it's a notable, it's a considerable part of the business. It's a part of the business that can't be ignored.
Yeah.
Now, and I think this is Your Lordship's point, there is a slight difference between the parties on this. HMRC would say, as we've said throughout, that the required influence is over the affairs generally, i.e. the sort of influence that the partner in a traditional partnership would have, at least formally. In practice, of course, different partners might focus on different things, and some responsibilities would be delegated to committees, etc. But ultimately, the partners would be responsible for the whole business. That's the sort of influence we say we're looking for. The appellant says it's possible for a person to demonstrate significant influence generally by demonstrating significant influence over part, if that part is a significant enough part of the whole. I'm not sure. Well, I think that is a difference, at least in emphasis, between us. Whether it's a difference in practice would, of course, depend on the individual case. But neither of us is now endorsing quite what the FTT said, which is that you can look at each aspect of the business separately. And then finally, on common ground, it's common ground that although it's helpful to look at the various aspects of the test separately, ultimately one has to put the jigsaw back together and construe the phrase as a whole. Now, that was the common ground with some minor differences, although important. There's obviously one very significant difference between us, and that's whether influence is limited to, or at least focused on, decision-making at a strategic or high level of management, rather than at an operational level, or as including an operational level. The reason perhaps we use strategic rather than management is that management can cover both levels. You can have high-level management or day-to-day management. Our position is that the focus is on the strategic or high-level management in line with the Court of Appeal. That's the Court of Appeal, paragraph 70 at page 155. Because, well, we say it flows from the words, of course we do. We say that is the sort of influence that one can imagine existing over the affairs generally, but also it's because it best reflects the test, which is intended to differentiate between employees and partners. Again, that's just what the Court of Appeal said. Sorry, in our case, that reference to influence being over the affairs generally, pointing in favour of the influence being strategic, is in our case paragraph 74, bundle page 93. I don't think we need to turn it up, but of course we can.
Which paragraph of the Court of Appeal did you say? You said page 155, 70.
70 on 155, if I've got that right. It's the second half of that paragraph. Well, maybe it's the final third. More generally, a focus on the decision-making at strategic level, rather than on how individual members perform their duties in conducting the business, seems to me to accord better with the basic purpose of Condition B, which is to provide one of the three tests which, if any one or more of them are satisfied, prevent a member from being treated as a disguised employee instead of as a self-employed partner.
So that's the line that you are essentially drawing, is it?
What, between high level and day-to-day?
Yeah.
Yes.
Or strategic and operational, I think
Yes.
you just described it as.
Yes. We're using several different words to illuminate the divide rather than trying to replace.
Well, what words are you using?
Well, we're using those words, yes.
Are there any others you're using?
Probably. I've used the word management in different. I've used high-level management, day-to-day management. We've used strategic and operational. Sorry, my reticence is I don't want to replace the statutory words with different ones of my own. I'm just trying to illuminate the statutory.
Yeah, but it's crucial for us to know how you are seeing.
We're seeing it very much as the Court of Appeal saw it.
The test.
So I'm very happy with the formulation that the Court of Appeal has set out there.
At the last third of paragraph 70.
Yes. And we're generally very happy with the Court of Appeal's approach. So, friend.
And are you going to tell us how that works in relation to this LLP arrangement?
Yes.
Okay. Because I'd like to know where you're drawing the line in terms of the board, the executive committee, those types of arrangements within this LLP arrangement.
Okay. I mean, we weren't going to go in detail through the governance of the LLP. We were going to focus on the application of the tests to the portfolio managers and see what their responsibilities are and what involvement they have, if any, in the necessary high-level decision-making. We're doing it that way round.
Right.
But I hope it gets to the same place.
Okay. Right.
Yes, and to be clear, it is accepted that the board and the original EXCO fail Condition B, that they have sufficient involvement, sufficient influence over the affairs of the partnership.
Sorry, that's the
Board and the original EXCO.
Well, indeed, it's because you say they do that the others don't.
Yes, well, partly.
I mean,
partly.
Because clause 14, I think it is, of the LLPA says that, well, and other clauses say that the conduct of the business is vested in the board.
Yes. I mean, that's obviously what the judge picked up below.
Yeah.
That in a sense, you might think that was the end of it. Clause 14 says the business and the affairs of the partnership are under the management and control of the board.
Yeah.
You might think that was the end of it, but
But you're not saying that it's confined to the board and the original EXCO?
we're not. Well, sorry. In this case,
Yes,
I think we are.
yeah.
You are
In
saying.
general, we're not saying. We're starting with trying to construe the legislation and then apply it. In this case, so in general, we accept that people outside the board could have significant influence. In this case, we're not accepting that any of the portfolio managers who aren't on the board or EXCO have significant influence.
Actually, you probably accept that the two corporate partners have the requisite influence.
Well,
Not that it matters, because they're not
individuals, so it doesn't matter.
But if they hadn't been corporate but were individuals, they would have had it because of their power to control who's on the board.
Undoubtedly.
Yeah.
And, well, that we would accept that Mike Platt, were he a member with the rights that he holds indirectly and practically, I mean, that would certainly amount. I mean, another simple answer to this would be that there is no room for anyone else to have significant influence because he has so much influence. But again, because we're starting with the construction of the statute and then trying to apply it, we're approaching it slightly differently. Now, that was our test, that we're looking for this high-level, strategic, if you like, influence over the affairs of the partnership generally. The appellant's position is that I think ultimately it's an evaluative test taking into account all factors. I took that from the transcript, yesterday's transcript. In the draft was page 96, line 14. I'm afraid I didn't get the final version in time to have an updated reference, but I think that's how my learned friend put it yesterday. And that includes...
Sorry, can you say how she put it yesterday again?
It's an evaluative task,
Yeah.
test, taking into account all factors. As I say, in my draft, that was page 96, line 14. And I think included simply doing the job of an investment manager because it was a part of the core activity of the LLP. Now, the first point with respect doesn't really help because it doesn't explain what you're evaluating. It can't simply be, we say, value to the business. Clearly, we're looking at more than that. We're looking at a power or an ability to make a difference to the direction of travel of the business. I'm trying not to just use the word influence. It must be more than the value to the business. Then on the second point, we would say it's clear that simply doing your day job or doing your job within the day-to-day business is not a sensible marker of partnership at all. We had an exchange yesterday between my then friend and my Lord Richard saying there's no suggestion that simply because someone's an accountant in a firm of accountants, they're more likely to be a partner than an employee. So the fact that you're engaged in the core activity of the partnership, even if that's the proper way to describe it, isn't an indicator of partnership. Again, I think that was page 131, line 4. Sorry, what's that from? Oh, sorry. Apparently that's become page 139, line 6, which means my first one will be miles off as well. So my first one had become page 102, line 17. So my learned friend's submission was page 102, line 17, and the exchange was page 139, line 6. I mean, obviously, with the exchange, it doesn't really matter. It's just the point is either a good or a bad one. We say it's a good one. That it is no indicator of partnership that someone is doing a, quote, core activity as opposed to some other activity. That isn't the approach taken, and that's not a sensible way to read the condition. Anyway.
It's not so much whether it's a mark of partnership. I think you've got to tie it more, haven't you, to the words of condition B.
Oh, well, yes, ultimately
yes,
whether
whether doing the day job means that you have significant influence over the affairs of the partnership.
I mean, it's a very odd way to put it. If what you mean is, are you doing something that's important to the partnership?
Yeah.
The test is looking, we would say, clearly looking for more than that.
Yeah.
If it's true for accountants, we say it's not conceptually different for investment managers. This was my point. It seems to me that the appellant's argument collapses into a requirement only that the relevant member is or has a role that is important to the business. I say that because if we look at the written case, their written case, paragraph 67, which is on page 49, the argument seems to be the appellant, the LLP exists to generate returns for BlueCrest and fees for itself. This depends on investment decisions. The people making those decisions are the desk heads and the portfolio managers, and therefore the desk heads and portfolio managers are exerting influence over the business and therefore the affairs of the LLP. And we say that really just amounts to saying they're doing the core business.
That was, which paragraph again?
It's 67 in their written case. It's not really exertion of influence over the business, it's the carrying out of the business. That's what they've described. And the test isn't, do these people participate in the carrying out of the business? It's whether they have influence over the affairs, we would say generally. That's a different test. And that's the Court of Appeal. We say the decision is very much in line, unsurprisingly, with what's now common ground, and accepts the revenue's point on the level of influence required. We've just looked at that. We've set that out. I don't think it needs to be turned up. In our written case, paragraph 79 to 80, we just summarise the Court of Appeal's position.
Page.
I've said above, it's true that the Court of Appeal doesn't refer to rights derived from particular roles, but we would say neither does this exclude them, and the relevance of that is a matter for the remitter. So the challenge, the remaining challenge to the Court of Appeal's construction of Condition B, sustained by the appellant, is the level of required influence, and that's what we've just been talking about. The level at which influence is exerted. Is it high level, or does it encompass everything, including the carrying out of the business? You have our submissions on that. Now, that's construction. There's obviously...
I mean, in a traditional partnership, as we discussed yesterday, you would have, I gave the example of 20 partners, they each have one vote at a meeting, they have responsibility for everything. But supposing in the case of this partnership, you had clause 14, but in a much stronger form, so that there was a large number of steps forming part of the high-level strategic management of the business of the partnership, which the board could not do without a positive vote from the members. Leave aside the question of there being the corporate member with an overwhelming majority. Would you accept that in those circumstances, the members would have significant influence over the affairs of the firm?
Well, where the members have meaningful rights to determine the high-level strategic direction of the firm. Yeah. I mean, it would be that would require an evaluation, but yes, potentially.
Potentially.
Yes.
I mean, the fact that their powers of veto, if you like, did not cover every aspect of the business, but was targeted at a significant number of important aspects, that wouldn't deprive them of having significant influence.
I don't think it has to be each and every.
No.
I think it has to be generally.
Such as to connote significant influence.
Yes, yes. I mean, it's quite it's maybe easier to say than work through in practice. I accept that.
Yeah.
It's not a hard-edged test like ANC.
But my Lord's example would come from the constitutional framework rather than the role that the member was doing as a portfolio manager.
Well, yes, it would, except it wouldn't take much to change the example so that we were talking not about a general meeting of all the members, but about a board consisting of the portfolio managers, so that your membership of the board, depending on your appointment to the role of portfolio manager, and then the argument would be the same.
Yes, that would be a strong position. Yeah.
I think the point I was just trying to tease out was this, that the board clearly in this case, I think, has overall responsibility for everything in the firm. So in that sense, it's like my example of the partners meeting in a traditional partnership. But it's not necessary in order to meet the, or if you like, to fail the condition B test. It's not necessary that you should have that total control. It's enough that you have influence over significant matters. I mean, of course, it's evaluative. I'm talking about a long list, just to make it easy for you.
Significant influence over significant...
Yes, yeah, that's just the point I was teasing.
My reluctance is just I don't want that to be taken as accepting that it's necessarily right that very significant influence over one significant matter.
No. That's why I took, giving the example of a menu, if you like, of 20, let's say, matters, which would have an impact, in practice, would have a significant impact on the way that the affairs of the partnership were conducted.
Yeah, and certainly if we're talking about 20 out of a possible 25.
Yeah, say.
If we're talking out of...
Yeah. Well, I mean, it might be a financial level of control, you know, no transaction over X thousand, or something like that.
Yes.
It wouldn't affect how much you paid the cleaner, but it might affect more significant matters.
Yes, depending how well you pay your cleaner, but yes.
Yes.
I'm thinking of our Chambers Management Committee.
Well, don't, for heaven's sake.
Yeah, so I agree. So at a high level, that's the construction. Now, on application, obviously, we're a long way apart. So how would the Court of Appeal's conclusions be applied to the facts found by the FTT, and whether a remitter is required at this point? Because the appellant says, I think, if you apply the law properly, you don't need a remitter because there are sufficient facts, obviously sufficient facts, in the FTT decision to say that they win. Now, in the written case, the points are put very simply. In their written case at 101, that's the bundle beginning at page 58. So, 100, on any view, the FTT found as a fact that the appellant's members had managerial or strategic influence. In the FTT, HMRC's counsel referred to managerial clout, and at 194, the FTT found that they had managerial clout. It's not as simple as that, and I'll explain why in a second. And then paragraph 101, wrong to argue the FTT made a material error in its interpretation of over the affairs of the partnership. HMRC's argument to that effect was wrong. We've already done that bit, really. That's, it was clear that we were arguing that it was influence generally. BlueCrest was arguing that influence over just the investment side was enough. And the FTT found in their favour. Now, on managerial clout, my submission there is recorded by the FTT in 130 sub 8 on page 203 of the bundle. Just want to see what I mean by managerial clout.
Sorry, page?
Page, sorry, 203.
Thank you.
And I think I've just said it's 130 sub 18. So I'm using managerial clout to refer to the sort of high-level influence that we say is required. This is a case where I regret using managerial. But when you read 130 sub 18, you see what I mean by it. But then we go to the FTT's finding on page 214.
What does the last,
Sorry,
what does the last two sentences of 130.18 mean, in particular the last sentence? Those earnings need to be translated into managerial clout. I don't understand.
Oh, I see. I'm saying that merely earning a lot of money isn't enough. But if, by dint of earning a lot of money, you end up having a significant influence, well then, so be it.
Well, that's surely performance.
Well, no, sorry. At this stage, we are accepting the possibility of de facto influence.
Oh, I see. Oh, fair enough. I follow. Yes. Yes.
So we're now on page 214?
Sorry, I got that. I took us to the wrong bit. It's 217.
217.
This is 194. I referred to this earlier. It starts with a discussion of Mr. Moore earning 300 million over 10 years. We say that's the sort of that's performance in the role, which is now accepted not to be the right sort of thing to look at for assessing significant influence. That's a clear mistake by the FTC. They would have made a significant impact on the financial performance of the appellant. Well, so what? That's not what the test is about. But on managerial clout, that's at the bottom. It talks about what the portfolio managers do and their roles, and then bottom third, these roles are absolutely fundamental to the core activity of the sub-investment manager, namely to maximise its sub-investment fees, and the evidence shows that these portfolio managers demonstrated managerial clout in the discussions with other portfolio managers concerning managerial and operational issues, which, if necessary, were then ratified by the board or UKSC. Each such individual's view was of significance, as was their influence. We say, that isn't accepting my argument. Sorry, it's not denying my argument. It's using the same words, but to mean something different. So it's not talking about managerial clout in relation to strategic decision-making at the highest level. It's referring to managerial and operational discussions with other portfolio managers. That's just not the same thing at all. It's not a finding that they had the right sort of influence, and i.e. influence over the affairs of the partnership generally. And it's certainly not a finding that they derived any such influence from the mutual rights and duties, as opposed to personal qualities and performance. Now, I said in passing just now that, of course, it was common ground before the FTT that a de facto test was to be applied, or at least it was by the time we got to the end of the hearing. We say that's clear, and it's clear that that's what the FTT was applying. If we go to bundle page 215, paragraph 188, in the written case, BlueCrest is saying paragraph 27, bundle page 36. We don't need to turn it up, but that's the reference. That the FTT wasn't applying the de facto test, but if we look at 118, we can see what is happening. Both parties accept that significant influence does not need to be exercised through a formal constitutional procedure, but requires a realistic examination of the facts. We say that is another way of saying we can look at de facto influence, a realistic examination of the facts. In any event, as I've just shown, when deciding the point and concluding at 194, it's clear that the FTT is looking at de facto influence, not just formal influence. I mean, the conclusions start, I don't think we need to turn this up, they start at paragraph 189, where we see various discussions of how decisions are made. And then in 190 to 192, the FTT focuses on the activities of the portfolio manager, not their rights and duties. It says that they behave like partners in a traditional partnership, meaning they're a professional services firm. I've said in my note it's not clear how that approach derives from any consideration of mutual rights and duties. I mean, it is clear that it doesn't. And then in 193 to 5, this is the bit we've just looked at, the FTT looks at whether any individual portfolio manager has significant influence and bases the conclusion that they do on the impact on financial performance and the demonstration of personal managerial and operational qualities required of a partner. Reference to managerial clout, but I've shown that they don't mean, he doesn't mean by that the same as we meant. In short, we say it can't sensibly be argued that the FTT actually applied a test based on mutual rights and duties as opposed to de facto influence. Now, that was addressing what was said in the written case. I'm aware I'm in danger of going over my self-allotted hour, but we will still be within our overall time if I go through the additional passages that my then friend referred the court to yesterday, just to show what they actually say and what they actually demonstrate. So this will take a little time, but hopefully not more than 15 minutes. So in relation to portfolio managers, this starts bundle page 177. (28A). This is the role of PMs. Well, we know the PMs are obviously involved in the investment management side of the business. Turning over the page, B refers...
Can you just remind me, for what precise purpose are you taking us through these references?
Well, my learned friend said yesterday, this is what the FTT found the portfolio managers did,
yes,
and also the desk heads, and why we BlueCrest say that translates into the requisite source of significant influence.
Yes.
I'm saying we need to look at those, partly to see the limit of what was found, and also for me to give my comments and explain why it doesn't add up, as my own friend says.
Right.
It isn't because I don't trust the court to perform that exercise on its own, of course, but since I'm here and I've got time...
Absolutely.
No, we're always anxious for help.
Absolutely.
So, page 177, paragraph 28. 28A is setting out the investment side of the business, and one sees the portfolio manager's role in that. But B sets out the support service side of it. There's no hierarchy given in 28 between the two sides of the business. The portfolio managers have no role in the support services side in that paragraph. Paragraph 37 is the next one referred to. Page 179.
Thank you. Yeah.
So I think that's probably just background. So the portfolio managers have a capital allocation which is, in effect, the amount of risk they're allowed to take on. It's not that the 100 million is put in their bank account and they can pay with it. It's the amount of risk that they're allowed to take on. We'll come back to the level of discretion they have and the bounds they put on that discretion in a minute. Page 188, paragraphs 85 to 86. Here we are, in fact. These refer to the portfolio manager's expertise. They're hired because they're good. They have full discretion to incur risk within their own strategy. 86, they're given full discretion, although their activity is scrutinised by Group EXCO and the risk team to ensure they're not investing outside their expertise and to rein them in if they're making material losses. That's 85 and 86. That all needs to be read with the previous paragraph 84, beginning on the previous page. There's ongoing monitoring of portfolio managers by desk heads and by Group EXCO.
Well, desk heads are portfolio managers.
They're a subset of portfolio managers. I'm going to deal with them separately, although there's overlap. There's monitoring. If there are concerns, maybe more detailed monitoring at the request of Mike Platt, risk team might review the position, and everything will be reported to Group EXCO, and then you might get fired. So, yes, they have full discretion, but if they step outside the relevant bounds or make a loss, then there are procedures to rein them in. Paragraph 97 at page, the wrong page number down, at page 190, sorry, 189.
Sorry, what one?
Yes, 97.
97 on page 189.
I see. Thank you.
Yes, it says they're involved in hiring new portfolio managers.
I didn't know what that meant, actually.
Well,
involved in.
It quite. Reading the whole paragraph, it's relatively limited, and it doesn't extend to other members of staff, and it's subject to board sign-off. So yes, there is involvement.
But they don't make the decision, is that right?
It doesn't tell you who makes the decision, except the ultimate sign-off remains with the board.
Well, actually, yes. Following interview, if the candidate is successful, this is escalated to Group EXCO for approval.
And then ultimately. But it doesn't tell you who in practice makes the decision or who in practice carries out the interview. But the ultimate decision is not theirs. So yes, involved. We say relatively limited. It's not that they are. It's not that they have complete control over their team or anything like that. 104 to 105 on page 190, talking about dealings with counterparties. Yes, we accept the dealings with counterparties, but reading those paragraphs in full, we can see that in certain circumstances, others might step in the middle of 104. If such relationships were going sour, then it was up to the portfolio manager to sort it out. But there were relationship managers and more senior management who might step in to assist. So yes, of course, portfolio managers have a role in relationship management, but it's not unfettered. And then 105 is about the evolution of those relationships. How it started with Mike Platt. But things have got too large for one person to be on top of everything. 127 on page 194. This is in the middle of a section about Mike Platt. So it's really saying, it's talking about his involvement, and incidentally it says he can't oversee 60,000 positions. A lot of management decisions, therefore, are managed at a local level by portfolio managers, desk heads, and UKXCO. Well, okay, but the ultimate say is with Mike Platt. And if one read from the beginning of the section at 123, that would become clear. So what the portfolio managers are doing there is the low-level day-to-day management of the trading positions. It's not a strategic management. Again, I don't think the court needs to read it now, but that section does give a good indication of Mike Platt's influence in the position. And the exchange recorded in 128 in particular gives that flavour. I think that's probably reading for later rather than now. 185 on page 215. The activities. Their role was to make investment decisions, make money for the partnership. Well, I mean, that's true, but we've already had that point. That's not the right sort of influence. 186, on an operational basis, they were involved in the sort of activities which a partner in a traditional partnership would undertake. Again, bearing in mind that what the judge has in mind is a professional services partnership. I say that if one goes back to page 213, pages back, paragraph 174, that's perhaps clearer.
Well, I think this is the test that the FTT judge applied. He looked at what he called a traditional partnership. He said, what does a partner do? A partner does the business. Lawyer deals with clients and so on. And if that's what a portfolio manager is doing, he's likewise doing what a partner does, and therefore he has significant influence. That seemed to be
yes,
the judge's approach.
It's been reduced to an activity-based test. Does this person look like a partner? Not does this person have the sort of influence that the partner would have. It's very clear we would say 174 on page 213 is the reference to a partner in a traditional partnership, finding, minding and grinding. Not sure. I mean, that was a new one for me. There's apparently a normal way of looking at matters. So that's the sort of thing he's got in mind. So he takes that as the paradigm example and then says, well, do the portfolio managers look a bit like that? Answer, they do. They look a lot like that in this case, and that's enough. So 174 is sort of setting that up, and 185, 186 is the payoff. And the problem with that is that it just isn't something that differentiates partners and employees. All those things could be done by, and will be done by, employees. A professional services firm, a senior associate, will do all those things. Find clients, supervise more junior associates, carry out work. Doesn't tell you anything about their status as between partner and employee. It tells you what their job is, well, so be it.
Well, even if it did, you would say that's not, but it's still not the correct test. The correct test is influence.
Well, yes, I would, but yes, I would say that. But the reason I'm discounting this as a way of looking at influence is that it's not one that differentiates, as this test must be intended to do, between quasi-employees and true partners. It's just, it would be a bad test, and we shouldn't attribute that to Parliament. And then that ends back where we were a minute ago at 194, and we can see the factors that ultimately the FTT pulls out, which are financial impact. Well, that's not.
Sorry, where are you now?
So we're back to 194 on 217.
194.
Yeah.
Thank you.
Just back to here. So having had that longer exploration of the rules, etc., we end up back at 194 and we see what he actually pulls out. Now, it's a parallel exercise in relation to desk heads. I think this is worth doing. I'll try and do this a little more quickly. Starting on page 180, paragraph 39. We've been talking about portfolio managers. I think this was your ladyship's point that desk heads are also portfolio managers. So within the category of portfolio managers, there are desk heads,
Yeah.
paragraph 39, who manage a team of portfolio managers. Some hold their own capital allocation, others don't, but oversee a team or a fund. Paragraph 80, page 187. This isn't developed, but I think this is, as a matter of fairness, worth flagging. One of the things that the desk heads do is sit on the London Trading Management Committee, which is an investment management committee which discusses matters affecting the investment management community, including hiring technology and counterparties, made up of desk heads and some other investment managers. It has a key role in the management and affairs of the appellant, and it has responsibility for operational risk. There's a forum for interaction between front and back office, which is essential to ensure the efficient running of the investment management function. Now, we would say, we would accept that committee as a whole appears, from what's said here, to be involved in the sort of decisions that might amount to significant influence. I won't go further than that because we haven't got any detail. That's not a concession by me that it does amount to it, but it might. But what we certainly don't have is a finding that any individual given desk head has significant influence simply by virtue of being on that committee. Anyway, we would say that is probably the closest that we come to seeing a link made between any of the people we're talking about and significant influence of the relevant sort. But it's a sort of throwaway comment. It's not something that's developed by the FTT later. Then paragraph 83, and we looked at this for portfolio managers, but we see here that one of the functions of the desk head is to propose capital allocation jointly with the head of risk, which then goes to Group EXCO. And that's discussed and ratified by UKSC and ultimately agreed by Group EXCO. Well, okay. So the desk head makes a suggestion. Obviously, it's an informed suggestion. Obviously, there are people who are good at their jobs. But it's a long way removed, we would say, from being the ultimate decision maker on that point. So it has to be seen in context. 84, monitoring of portfolio managers by desk heads. Again, we've seen this. But ultimately, it's the risk team, it's Group EXCO. So they're involved, but they're not at the top of the tree. 87, some desk heads have slightly wider responsibilities. And I think that's what is being said. It might be said simply that some portfolio managers are also desk heads. So this might just be repetition.
I think that's how it reads to me.
Just repetition, yes. In any event, it doesn't take things further. Paragraph 100 on page 189. Sophisticated risk framework to manage portfolio risk, established by Group EXCO, updated in 2020. Day-to-day responsibility for portfolio risk management is delegated to the desk heads. This might be quite a good example of what does and doesn't count. It's strategy, risk management framework determined at the top level, day-to-day management or implementation of that carried out by the desk head. We say there, yes, I mean, they're involved in something important, but they're not at the level of strategic influence. They're at the level of implementation or operation, or day-to-day management, not high-level management. It's part of their day job, part of normal operations. Next page, 190, 107. This is new products. So if a portfolio manager wants to invest in a new product or market or engage with a new counterparty, reviewed by the new product committee in the first instance, might be approved. Other requests will be passed to Group EXCO, and so on and so forth. The decision on what to escalate to Group EXCO is a judgment call for the desk heads and Mr. Cox. So yes, the desk head is involved in the approval process for new products, but we would say in a very subordinate way. And then paragraph 195 on page 217 is the conclusion in relation to desk heads. So they're portfolio managers in their own right, so we import what's just been said. We say, oh, that doesn't really help us, but that's the reasoning. They're also responsible for monitoring the day-to-day performance of other portfolio managers on their desks. True. We say that's not significant influence. That's, well, exactly what it says. It's day-to-day monitoring. And play an important role in settling individual portfolio managers' capital allocations, recruitment, and new product initiatives. Well, we've seen what the role was. I appreciate it's an evaluative judgment by the FTT that it's important, but we would say if we go back and look at those things and the individual findings in relation to them, there's a stretch too far to say that those can possibly amount to significant influence. So we would say, although there's no doubt that the portfolio managers and the desk heads are relatively senior individuals within the business and that their activities are central to one strand of the business, that doesn't amount to significant influence. We've seen what they do. It falls short. What they are responsible for is investment decisions that generate performance fees. And they are involved in related aspects of the business, such as hiring in a subsidiary way, and particularly for desk heads supervising other staff. Although ultimately that's down to the board, EXCO, in some cases Mike Platt. This is important work, but none of it, except perhaps the London Trading Committee, comes close to being influence over the affairs of the LLP generally, as required by the test properly understood. The FTT has wrongly focused on the activities of the portfolio managers and desk heads and asked whether they do the sort of things a partner in a traditional partnership, professional services partnership, might do. They're all things the worker might do as a partner or an employee. The FTT hasn't asked the proper statutory question of whether these people have the sort of influence over the affairs of the LLP generally that a partner in a general partnership might have. So I hope that's descending to the level of detail on the application that's helpful to the court. Although I've done it, as I say, by looking at the roles of the portfolio managers and desk heads rather than focusing on the governance structure. I hope my learned friend covered that sufficiently yesterday. I said I would come back to disposal, but I think it might be helpful just to make 3 quick points on disposal because they flow quite naturally from condition B. And I'm still going to leave my learned friend time for condition A and time for any questions that might have arisen for any of us. So I'm on course. So if I may, on disposal, as we see it, there are 3 options. I think this is common ground. First, if, as we say, the Court of Appeal was correct as a matter of law, there's no reason to interfere with its order. The case is remitted, subject to the Court of Appeal's direction. If the appellant were right, that even on the Court of Appeal's view of the law, it's clear from the FTT's finding that the portfolio manager and desk heads fail condition B, then the appeal will be allowed. Decision of the FTT reinstated. I hope I've correctly reflected that outcome. If the appellant is right on the law and identifies an error in the Court of Appeal's reasoning, so if it's right to that extent, but doesn't establish the FTT's findings are sufficient to determine matters on the basis, then the court would need to reconsider and might need to vary the Court of Appeal's order. There'd still be a remitter, but one might need to reopen the position on evidence. That would depend on precisely what error was identified and whether it was material and so on and so forth. For example, it's clear that the FTT was looking at de facto influence because of the parties' agreement. That's accepted as wrong. But it doesn't entirely ignore formal influence, and there was evidence before it going to formal influence, so it's not clear why more evidence on that would be required. However, we're not proposing to go into detail on that now. We would, of course, be happy to make submissions orally or on paper in due course if the court requires further assistance on that. So I don't think I need to come back further on disposal, though, of course, I can do so if there are questions. Condition A.
So your position is absolutely clear that it's not for us to make the final decision, that it at most would go back to the first instance?
We're not asking for a final determination completely in our favour, no. We're accepting that success for us is the remitter on the Court of Appeal's terms.
Thank you.
Yes, thank you.
Thank you. Now, I propose to focus on condition A alone. What I wanted to do is begin by looking at what the remuneration arrangements were in the present case, then look at the interpretation of the legislation and how it applies to that arrangements after that. I don't think the court, I'm no doubt the court has read this in the first tier tribunal's decision, but the court wasn't, I think, taken to this in any detail yesterday. I think the easiest place to see the arrangements is, in fact, in that decision. I'm not proposing to go back to the LLP agreement, but I'm very happy to if any member of the court would like me to do so. The first tier summary is on page 180, right towards the bottom, paragraphs 46 and 47 over onto the next page. If I could ask the court to read those.
So we're really concerned with B.
Exactly, my lady, yes.
So 47 enables us really to ignore C, doesn't it, for this purpose?
Yes, in the sense that the points allocated to the individuals were not significant enough to be taken note of, exactly. But the reason I'm showing you the whole structure is because that does impact how all of this works. It impacts how the discretionary allocation works. We start with these priority distributions, which if we look at it in the terms of the portfolio managers alone, those were generally around 150,000 a year. There was a letter of allocation that stated what those would be. We don't have one in the bundle, but the first tier looked at those and mentions those. So those are fixed and they are disguised salary. There's no dispute about that. That's the basic the portfolio managers are going to take home every year. Then the next in order is the discretionary allocations, and those are the centre of the dispute here. Those are determined at the discretion of the board, but we'll have a look at how that discretion was to be exercised. There is a policy document. It's not a completely, it's not completely free range, as it were. And the portfolio managers called that their bonus. And then we have the income point allocation. So that is all the residual profit being swept up the group. So if the whole LLP does particularly well, all of that residual profit doesn't go to the portfolio managers. It gets swept up to the organisations at the top of the group and ultimately to Mr. Platt, or including Mr. Platt. And we can see in practice how that actually worked. We, of course, accept this as a prospective test at the beginning of at the relevant time, but just as a flavour of how that worked, we can see it at page 183. Where we can see that the allocations, total allocations given to individual members and PIP facilitators. I don't need to trouble you with PIP facilitators, thankfully, but broadly that we're treating those as if they're discretionary allocations to individuals. That's the penultimate column, and then in the final column we see the amounts that were, as it were, swept up to the other corporate members. So in each year we can see that substantial profits were allocated to individual members, that's portfolio members and infrastructure members, but there were also profits available to go up the structure via the corporate members. Now if we look at how the board exercised its discretion, we have the policy document in the bundle, but again, I'm just going to go straight to the first tier decision. We can look at the document if necessary, but the key parts are quoted. Page 184, paragraph 64 for the portfolio managers. Again, if I could just ask the court to read that paragraph. So we see the general policy there, and that mentions a methodology, and that an example might be 20%. We see how it can actually work on an individual basis at paragraph, page 183, paragraph 59. Yeah. And effectively, you have a calculation based on the net profit or loss of the individual portfolio run by that manager. And then you have the headline percentage applied to that. So whether that's 18% or 20%, it's a percentage applied to the individual portfolio profit or loss. No part of that methodology takes into account the overall profits of the partnership. I don't think we need to go through it in detail, but page 184 at 65 and 66, we had two portfolio manager witnesses who worked through how that worked for them as individuals, and confirmed the summary we've just looked at. And we can see in those examples, those particular individuals, that there is an absence of any connection between the profits of the LLP and the discretionary allocations that they received. So, for example, Mr. Moore in 1 year made a loss, and so he only received his 150,000 plus £1 for his income points. So even though BlueCrest as a whole made a profit, he didn't get a bonus. So the focus is on individual performance. Now, while the appeal is strictly concerned only with portfolio managers and desk heads, it is also worth understanding how discretionary allocation works for the other members, the infrastructure members. That was set out in the same document, and we have the relevant quotation at page 185. It's at the top of the page where it starts non-PMs.
Do we get an indication of how the variable remuneration pool is itself quantified or established?
Purely that what we have, I think, in... we have some how it was established in the sense of which people were involved in it.
No,
I don't have it in a quantification.
By what formula or calculation, or
No.
it may not be rigid, it may be...
No, we're not told that it was rigid or that it was a particular share of the profits or anything like that. It's a top-down assessment taking into account multiple factors. So we see strategy, performance, and future financial stability. We see that at the beginning of that quotation. Yeah. But no, it's not said that it's, for example, 20% of the profits or anything like that. It's a put everything into the mix to identify the pool, and then put everything into the mix from the bottom up to identify who gets what out of that pool. Again, looking at individual performance, but it's not formulaic for these people. I'll come back to this idea, but that is very much like an employee bonus process. You need to identify how much you're willing to pay them as a total, and then identify who gets what out of that total. And we get... Again, we don't need to go through this in any detail, but the paragraphs immediately following 69 to 70 is the evidence of Mr. Cox talking about both his own remuneration and an example, an anonymised example. And again, we see a complete lack of connection between the profits of the LLP overall. There was a year where Mr. 73 on page 186, Mr. Cox's taxable income was considerably greater in that year, even though the appellant's profits had fallen. So 69 to 70 and 73 to 74 gives us a flavour of how it actually worked in practice. So that's how the remuneration arrangements worked and were set up. We could see this prospectively. Now, despite that lack of connection between the overall profits and the discretionary allocations, BlueCrest now argues, well, there was a cap on those discretionary allocations. Well, sorry, it's always argued there was a cap. There's no dispute about the cap, but it argues that that cap is enough to say that these allocations were varied by reference to the LLP's profits. That cap isn't found written down in the LLP agreement, but the policy is said to have been that BlueCrest would not make discretionary allocations which exceed the total profits available for allocation. We don't need to go there, but the first tier's findings, just for your notes, were page 181, paragraph 46B, page 192...
Hold on.
I'm sorry.
181.
181, paragraph 46B.
That doesn't say... Oh, that just says can't exceed.
Yes, exactly. None of this is pointing to where it's written down. It's just what the first tier said about the cap.
I thought there was an exchange of correspondence.
There was a process which happened there was a tax paper that was produced
Yes.
and a resolution
Yeah.
that was made, but it is now common ground that that has to be ignored, because if that did have any effect, then
Meets the tax.
it meets the test for the anti-avoidance provision, but also the references, I'll give you some more references. They show that the evidence of Ms. Kerridge, who was the head of tax, was that the document, the resolution, was simply reflecting the existing policy. So the best we have is that the document reflects the existing policy. So page 192, paragraph 116. That's where we get the confirm the existing policy point. And then page...
But this cap is a reference back to which? That's to 115 sub 2?
Yes. Exactly.
Not exceed in aggregate total profits available
Yes.
for that purpose for a given year.
Exactly. So there we see at 114, we see the point I just made. There was a tax paper that was produced and a recommendation as to what the board should do. And then 115 records what that resolution.
Looking at it, the cap has two levels, doesn't it? There have to be enough total profits, but within that there have to be enough total profits allocated for this purpose. It's the profits which are available for the payment of discretionary
Yes.
allocations.
Yes.
So
That's the variable remuneration pool point, is it?
that's
I
different.
wouldn't like
That's
to say
different
what
from the-
it's doing, but what I do accept, what that level is doing, I'm not sure anyone is seeking to rely upon. The level that BlueCrest is seeking to rely upon is it's the total profits available acts as
Yes. So that if there are no profits, then there's then there's just no room for
and no discretionary allocations.
any discretionary allocations. If there are profits, it doesn't mean that the whole of the profits are spent on discretionary allocations.
No, and we've seen that in the table that I
Yes,
showed your lordships and
absolutely.
the lady.
Yeah.
If BlueCrest has a really great year, the money doesn't have to go to these individuals and doesn't go to these individuals. We see that with hindsight, but we know that from the policy as well.
Yeah.
There's nothing to require that, or nothing to give them a right to it. Did I complete the list? I think I was going...
So it's common ground that there is what can loosely be called a profits cap.
Yes, but with no detail about how that works, that
No.
it's simply a cap that says you can't give out more. I think the phrase the first tier and the tribunal and the Court of Appeal have all used is you can't dish out more than the allocated profits. Sorry, than the profits available for allocation. So we don't, for example, have something to say, well, what you do is perform the methodology and then reduce everything pro rata. There's nothing that says that, and that wouldn't make any sense because there is only a methodology for the portfolio managers. There's no methodology or there's no formulaic methodology for the...
1152 comes quite near it, but it doesn't actually say pro rata.
No, it doesn't.
When you're doing the allocation before applying the cap to
Yes.
individual portfolio managers,
Yes.
you're looking at the profits they have generated on their debt.
Yes.
Yes.
Quite.
And there's, I think we saw a 20% figure
Yes.
of the profits of
Yes, of their net profit, exactly.
their
yeah.
net profit.
Yes.
But if you then tot up all those discretionary allocations
Yes.
and you find it exceeds the profit of the firm,
Yes.
then there has to be a reduction.
Agreed.
Okay, thank you.
Yes. But of course, at the same time, you're doing your non-formulaic calculation on the infrastructure members and identifying how much you're going to pay them as well. So it's all the cap applies to everything. It doesn't just apply to these portfolio
I
members.
follow that, yes.
I think the final reference was in the first tier, page 209, paragraph 151, and that's simply the judge there recognising that the witnesses didn't seem to have considered exactly how that abatement would happen. But there was, of course, the resolution, so someone thought about it in April 2014, but not in precisely how those allocations would be reduced.
Yeah.
So all we have is a cap that means that BlueCrest won't dish out more than it has available for allocating. Now, however it works, BlueCrest says that is enough to turn these discretionary allocations into not being disguised salary, but being something else, if we could call it a true profit share. So they say these allocations are amounts which are not varied without reference to overall profit, because the cap is a reference to overall profit. I apologise for the horrendous double negatives that I have to use when explaining how this legislation applies here. Now, what HMRC say, and what all of the courts below have said, is that a cap of this sort does not prevent these amounts from being disguised salary. So our starting point, as it has been with Condition B, is that Condition A has to be interpreted with the purpose of the legislation in mind, being to distinguish between individuals whose position is more akin to partners and those whose position is more akin to employees. It is worth bearing in mind that Condition A can only be met where there is an individual who is performing services for the LLP. So we're only looking at individuals who are actually carrying out work for the LLP and receiving payment for that work, which is, of course, consistent with that aim overall of the legislation. And we say that partnership law should inform the interpretation of Condition A. Mr. Kirby's already happily taken you through all of that, so I need to no more than a brief reminder that Section 2(3) of the 1890 Act provides that receipt of a share of profits is prima facie evidence that the recipient is a partner, but does not of itself make that person a partner. And in line with that provision, in the cases we've seen that profit sharing is one of the factors which the courts take into account in determining whether an individual is a partner or an employee. And they look at, if I can call it this, a true interest in the partnership profits. I'm not proposing to go back to these cases unless there are any particular points the court would like me to address. Now, as Mr. Vlatt said this morning, and as with the other conditions, Condition A draws on that partnership law, but it also adds a hurdle to reflect that this is just one condition, that one need only meet one condition to escape the Salaried Members Rules. And the hurdle that we have here is this 80% threshold, which we don't, of course, see in the case law or in the 1890 Act. So, with that background in mind, if we're looking to focus on remuneration, the contrast might be between a traditional partnership, where all of the partners have an interest in the profits being as large as possible. So whatever share they're going to get, it matters that the partnership profits are as large as possible, and those profits are then divided in the agreed shares, whether that's income points or percentages. Contrast that with an employment relationship where the employee's fixed salary might be topped up by a discretionary bonus, which rewards the employee for their performance or efforts. In that situation, the overall bonus pool might well take into account overall profits, might do exactly the same as we've seen for the non-portfolio managers, look at financial performance, future stability, future strategy, etc., but it's not linked to those profits in any concrete way. It's not a share of those profits. So we have all of that in mind when we turn to Condition A itself. That is page 592. Yeah. I'm afraid the key part does break over the page onto the next page. So I'm going to begin with Lim B because that is our primary case. So that's over onto the next page.
Just before you do,
Yes.
there's no magic in the label disguised salary, is there? In the sense that it is then precisely defined, so that whatever the precise definition means tells you what it is, rather than saying, well, you go back and say, does that look like a disguised salary?
Well, we say that that label simply reinforces what we're looking for.
Okay.
So yes, we're concerned with the definition. I'm not trying to do anything more with the
You're not trying
case
to,
law and say
you're not trying to interpret B by reference to whether B, one interpretation or another, looks more or less like something that we're trying to discuss.
Well, sorry, I am trying to interpret B. I'm not trying to apply it by saying, does one look more like the other? I'm not trying to apply it by saying, do we have something that looks like an employee remuneration pool, or do we have something that looks like partnership share? But I am trying to interpret the whole condition, and B, by saying what we're looking for is something similar to the partnership law. So fixed is obvious, because that an employee earning a salary would earn a fixed amount. Lim B then asks whether an amount is variable, but is varied without reference to the overall profits or losses of the LLP. Now, we accept, of course, that these discretionary allocations are variable, and the question is then whether the cap means that the allocations are varied with reference to the overall amount of profits. It's as simple as that. Now, BlueCrest argue for a very literal interpretation. There is some possible reference to the overall profits because of that cap in reaching the final figure, and so they say it cannot be said that the figure is varied without reference to those overall profits. But the implication of BlueCrest's position is that the only type of remuneration that would meet condition A is remuneration, or indeed B disguised salary, is remuneration which is payable irrespective of profits entirely. Or to put it another way, if the remuneration is completely divorced from overall profits. And that would be a surprising result for two reasons. First, it ignores the context and the purpose of condition A. So business performance and profit, in broad terms, as I've said, will often be taken into account in calculating bonus pools, and then you identify or determine the individual bonuses using a number of factors, personal performance and so on. If bringing profit in at that level, calculating the bonus pool in broad terms, is enough to say that the bonus amounts are variable by reference to overall profits, then condition A does nothing to distinguish between people like partners and people like employees. So it completely misses the purposes of the legislation. And the second point is that the interpretation deprives condition A of any effect. As I've mentioned, the court and the tribunals below recognise the basic position is you can't dish out more than your accounting profits dictate. So unless you've got some special provision or some special mechanism in your LLP agreement or similar, a cap of this sort will apply on the allocation of profits from any LLP, whatever the basis of the allocation. So if BlueCrest's interpretation is right, the legislation doesn't care how the remuneration is calculated or what it takes into account. It just cares that there's a cap and that might apply at the end of the day. So it turns any amount, however calculated, into not disguised salary.
Just trying to grasp that.
Yes,
Are you saying that any variable remuneration will necessarily be subject to a cap equal to that year's profits of the firm as a whole?
I'm saying if you have a straightforward LLP agreement that says here's how you allocate profits and some of that is discretionary, then unless there's a special mechanism in that LLP agreement, that allocation process is necessarily going to have a cap built into it.
Well, that's because the cap's built into the LLP agreement.
Yes, exactly. But what we're looking to do here is...
Doesn't mean to say it's not a cap.
No, I'm not saying it's not a cap.
And I don't think you're suggesting that an LLP must limit any discretionary payments to its people, let's call it, using a neutral word, its members, by reference to its profits.
No, I'm not. No.
It's not a
I'm saying you
statutory
could have a special mechanism.
It's not like distribution of dividends to shareholders.
No, no. You couldn't distribute more than your profits as profits, but you could make other payments. I accept that.
You could. The point. I mean, the point here is that you start, as we discussed a moment ago, with the profits of the individual desk.
Yes.
Now, that desk might be the only profitable desk in the whole firm that year.
Yes.
So so that there's an overall loss. Now, supposing the portfolio manager was an employee, are you saying that he couldn't be paid, as a matter of law, couldn't be paid a discretionary bonus because the firm is making a loss?
No.
No. So I'm just trying to understand your second point.
Yes, certainly. We are dealing here with LLPs and people who have been made members, and that
Right.
that comes with some default
Yes.
positions, rights. Those can
I
all
see.
be varied.
So your point 2 is limited to
Yes.
members of
Yes.
the LLP.
Yes, exactly.
I
So
see.
what we're doing is looking at people who are members and who will have some sort of profit allocation, and asking, is their remuneration disguised salary? And our starting point is they're going to get a profit allocation. So without some special mechanism, there is a cap on every LLP.
No, I don't think I understand.
Apologies.
In the rather artificial world of an
Yes.
LLP, which is somewhere between an individual and a partnership,
Yes.
why is it assumed that just because somebody is a member, he's in somehow sharing the profits?
Apologies. If they have any right to the profits, any right to profit allocations at all, the starting position is it's the actual
then
profits.
It would be capped by reference to the profits.
Sorry.
But why do you start with that assumption? There's no reason why a member should have any right.
Well, I'm starting with that assumption purely because in Condition A we're interested in what these people get by way of remuneration. But I accept that there will be some situations where they may get nothing more than a fixed amount.
But I still don't quite understand why, if you're a portfolio manager and
Yes.
a member,
Yes.
why, as a matter of law, because I think that's what you're saying,
Yes.
the discretionary allocation must be limited by reference to the overall profits of the firm.
It's not quite what I'm saying. It's saying that the starting point of an ordinary LLP agreement would be that there's a cap because you cannot dish out. I'm not trying to say any more than you cannot dish out more than the accounting profits dictate. So in order to move away from having a cap, one has to have a special mechanism or a special agreement or a special clause, whatever it is, to say we're going to give you more than the profits, or we promise that we might give you more than the agreement, than the profits dictate.
And that would be lawful.
Yes.
So you could have a case, couldn't you, where a portfolio manager was entitled to a discretionary allocation which was not capped by reference
You could.
Right.
You could. Or the point I'm making, and perhaps this is perhaps my first way around of putting it was easier than the second, that the cap doesn't change the underlying nature of the way in which this remuneration is calculated. So if we ask, is the remuneration varied with reference to the overall amount of the profits, we say no, because the way it's varied is by reference to the individual portfolio.
And the words, but is varied without reference,
Yes.
Would you say the words is varied goes back to is variable? So you say that the remuneration is variable by reference to the profits of the desk.
Yes.
But, well, yes, is variable, and that variation is without reference to the overall amount of the profit.
Exactly. So what we say is that those words with reference, without reference to, sorry, but if I end up in the double negatives again. The words reference to require something more than the overall amount of profits functioning as a cap. So they require the variation, the determination, to be by reference to the overall profits. And that is because if we go, I'm sorry.
It's ultimately a terribly short point, isn't it? I mean, whether
It
by
is.
reference to includes a cap or doesn't include a cap.
I'm sorry.
It's just a very short point about whether by reference to does or
Yes,
doesn't include
it is.
a cap.
Exactly. I'm very happy to move on.
Except that one might think you just sort of toss a coin, but obviously what you're doing is explaining how by reference to must include a cap.
It must not include a cap, because otherwise this provision doesn't meet its purpose. Otherwise, condition A does not do anything to distinguish between employees and
well, why? You could have an employee whose variable amount was effectively he eats what he kills.
Yes.
In other words, it's entirely by reference to what he's bringing in.
Yes.
And it's not capped by reference to the firm's profits.
Yes.
And one will quite easily see that was a disguised salary.
Yes.
So why is there no purpose of achievement in condition A if one was to regard a cap as coming within the concept of without reference to? Because it would still exclude, as people being paid a disguised salary, those who are eating what they kill without reference to the firm's overall.
It would, and that would be all it did.
Yes.
Yes. But what we say these words are doing, and this is with the partnership law context in mind, is to require the amount itself to be determined with reference to the overall profit, so that there's a true share of profits, rather than just a share of something else, or not a share, a number that is calculated and then has a cap applied to it. That's the difference we say there is, and that comes from both the words, but also from the partnership law. Perhaps a helpful example might be, we've looked at, well, no, I shall move on. We know in the present case, and we apply it in the present case, the underlying mechanism for portfolio managers is purely individual performance. And we say that is not varied with reference to the overall profits. And to the extent that we can draw on partnership law, it's more reminiscent of an employee's bonus scheme than of profit sharing between partners. And the fact that there's this cap doesn't alter the nature of that mechanism. If this court upholds the decision on this basis, there isn't any need to consider anything further. But I will just address the point my learned friend made yesterday as to the relevance of reasonable to expect. So this is on page 592.
Page what?
592.
592.
So if the court considers that a cap of this sort is potentially capable of amounting to variation with reference to profits, then HMRC's position is that condition A looks at whether it is reasonable to expect that the cap will actually have the effect of varying the amount. So we get those words in the first sentence of step 2 at the bottom of page 592. And my learned friend's position is that the words reasonable to expect apply only to the 80% threshold, whereas HMRC's position is that those words are relevant to the whole of step 2. So if we read condition A picking out the relevant bits here, then we say condition A is met if it is reasonable to expect that at least 80% of the total amount payable will be variable, but varied without reference to the overall amount of the profits and losses of the LLP.
But if you apply reasonable to expect right across the board, that might appear at first sight rather to sort of disapply sub C, because that's a different test, a sort of in practice test rather than a reasonable to expect test.
My lord, you mean that sub C wouldn't necessarily...
Why would you need it?
Wouldn't be necessary. It's a belt and braces in that circumstance. I accept it's a belt and braces in that circumstance, yes.
And do you say that because it refers to disguised salary in that same sentence?
Yes, exactly. So it's all one provision.
And then disguised salary is defined by the three limbs.
Exactly. So if we were to apply it here, we say, well, it's possible that the LLP wouldn't have made enough profits in any given year to make the discretionary allocations on the basis of the 20% methodology or 18% methodology, because the LLP may have faced some commercial risks and those risks may have had an impact on overall profit. But what there isn't is any evidence that at any relevant time it was reasonable to expect that the cap would apply. So at no point in the relevant period did BlueCrest say we expected the cap to apply, reasonably or otherwise. So no one considered it to be reasonable to expect that the cap would have an impact on those discretionary allocations. And the final...
But it's an objective. It's not what BlueCrest...
Yes, indeed, but a starting point to identify whether or not the cap might have applied is to say, well, what did everyone think was going to happen? And then we can look at that, what they thought was going to happen, and say, is that reasonable or not? But if no one is even saying, well, we thought the cap might apply, then no one's expecting it at all. I'm certainly not trying to change it from being an objective test. But an example of fulfilling that objective test might be to say, let's look at the profit forecasts for year 2, and we think our profits are going to be really very low, and the cap's going to apply. Was that a reasonable forecast, yes or no? But no one has put forward that type of evidence. And then the final alternative is limb C. So an amount within the total is disguised salary if it is not in practice affected by the overall amount of those profits or losses.
You'll need to deal with that quite quickly.
Yes, I'm sorry. I will, and I can. The point is simply, again, this is a prospective test. These are amounts which were not in practice affected by the cap. So while the cap exists, it was neither intended nor expected that the cap would actually, in practice, affect the amount produced by the calculation. So the existence of mere risks or possibilities of commercial difficulties does not mean that in practice the cap would apply. Yes, is that in our written case? My Lord Briggs asked about the relevance of the words disguised salary. We had covered that in our written case, and I failed to draw the Court's attention to that. It is in page 105 in our written case.
Page what?
Page 105, and it's
Thank
paragraph
you.
116.
Thank you.
We're at your disposal, but
You've run out of time, Mr. Dowd.
very happy with that.
Ms. McCarthy.
Thank you, my Lord. If we can please start with condition A so that it's all fresh in your mind. You should have the legislation in front of you already, page 592. Thank you. So I have the following discrete points to make. First of all, condition A could easily have said disguised salary is defined as fixed or a variable percentage of profits that does not vary with reference to M's performance of services. And I use the phrase M's performance of services because that phrase appears about 5 lines up in part and parcel of condition A, step 2. If the intention of the legislation is to say you have to have a percentage of profits and what we count as variation cannot be your personal performance, that is a concept that you already find 3 lines up in the words of the legislation. Instead, the legislation says without reference to overall profits. And that is all that we are interpreting here. You are also required to look only at M, the member, and ask what his payment does by reference to overall profits of the LLP. That's the beginning and the end of the test. Not what his payment does as a proportion of everyone else's payments, because that's the exercise the first year started to enter into. Well, how does this vary between member 1 and member 2 when you go back to the decision? 2, I think the cap labelling, which I have never adopted, I don't like the cap labelling because I think it has a tendency to be too suggestive. It sounds fixed, your payment is capped at 100,000. We have to remember here, at the start of the period, this so-called cap that we're talking about is variable, because it's profits, we don't know what they are, and it's necessarily an unascertained number. So cap can't be used to imply any sort of fix in what the exercise is here. And we say, when you have a payment that, you've seen the table at 57, the total amounts go up, the pool goes up. If there aren't enough profits, people's discretionary allocations reduce. That's the finding of fact. That's enough. Now, the revenue has not pointed to any partnership authority that tells us why that shouldn't be enough. Why partners in a partnership, why there's some finding in common law or elsewhere to say that actually no, the nature of a partner's payments must necessarily, as a matter of law, be something different. So what they can't do is say, we'll look at a common law partnership, look at a traditional partnership. This is how some partners might be paid. And so therefore we want to read that into it being a share of profits, a straightforward percentage that you know at the start of the year you'll get 10% of profits. This is the case because obviously a partner can be paid a fixed salary, a guaranteed salary, and a partner can be paid a variable salary, but it's nonetheless guaranteed. So what I mean by that, a fixed payment, my partnership share, I am guaranteed, regardless of the amount of profits, to get at the start of the year £20,000. What does it mean to be variable? I don't know that it's going to be £20,000 at the start of the year, but what I do know is I'm going to be paid £4.50 an hour. But that's guaranteed. I'm going to be paid £4.50 an hour, regardless of whether there are profits or not. That's my partnership share. Obviously, both of those examples are caught by A and B. Now, the fact that I can't list a lot of examples that potentially fall within Lim C, you'll have seen in our written case, we say Lim C is an anti-SPI, an anti-Scottish Provident type device. It's a safety valve. So if you've managed to construct something clever that on the face of it looks like it passes through A, on the face of it looks like it passes through B, but actually you've built in some sort of device designed to get around both, that's what C's there for. So C doesn't have to have a function in every single case. As I say, C, as we interpret it, is a safety valve, so people can't get around B by some sort of clever sleight of hand. Moving on then, please, to the point about employee wages. As the Court of Appeal and the first tier both noted, well, you can only pay an employee out of the profits you've got. I've already said in opening why that's not true. Employee wages, if you're just looking at a basic wage, the basic salary, they're owed whether they're profits or not. And I've also flagged, it's Steckel, page 745 in the bundle B to D. That draws a difference between, a substantive difference between, a firm agreement to pay versus a payment of profits, if any, up to a fixed limit. A, so a firm agreement to pay, represents your employee salary. B, represents something more on a partnership level. Profits, of any up to a fixed limit. And we're not even that, we're more than that. We're not profits of any up to a fixed limit. Necessarily, if we don't have enough profits, our sums vary. As I've already said about the employee bonus point, that's misleading because, sorry, I don't mean that pejoratively. I simply mean that that sends us down a wrong path. Those sorts of employee bonuses reflect the fruits of ownership where the employee in question doesn't have a stake in the company. So if this company performs well this year, then at our discretion we'll pay you an employee bonus. So bonuses, that's partner-like, and all we're being distracted by is the labelling. If these were called in normal parlance stakeholder payments, then we wouldn't have this distracting point. In substance, that's what they are. They incentivize employees to make them feel like they have an interest in the overall success of the company. That's exactly what a partner remuneration is doing. Now, the last point, which then leads me on to condition B, please. Of course, the general interpretation of the conditions is a matter for the court. But in terms of our appeal, condition A only matters to us if we've met, well, we know we've met condition C, but we've also met condition B. And we're at danger of meeting condition B if this court decides to accept HMRC's restrictive wording, restrictions into the language of condition B. We already know that conditions A and C have built-in thresholds that aren't found anywhere in the common law. We also know that the ultimate policy behind all of this was simply to draw a line between employees and partners. Now, obviously, that line isn't going to be precise, but that was the stated policy. We don't interpret legislation by reference to policy. We need to find purpose. But my point in that submission is saying there's no policy, if these are your employees and these are your partners, there's no stated policy to say, well, hang on a minute, we're not trying to divide these. We're actually trying to cut off a subset of true partners. That's not the policy behind the legislation. Now, reading in extra restrictions, extra thresholds into these conditions moves that bar even further and further into the true partner territory. And my simple point is, why is the plain and simple reading of Lim B and Lim C not acceptable? There's no policy purpose for reading Lim B or Lim C in a way that should catch more people than their plain language states. And you already have my submissions. All that you're being asked to do, obviously in the context of Step 2 as a whole, but the interpretation exercise and the application of this to our case is from the full stop after disguised salary. We're only interested in interpreting an amount within the total amount is disguised salary if, and reasonable to expect is not part of that definition test. Now, that's all I had to say on condition A. If I could then please move back to condition B, and I'm going to attempt to make my reply points roughly in the order that they were made, but if I can start off with this overarching point. At places in both Mr. Kirby's and Mr. Valat's submissions, they both used the language of ultimate control. They used the language of ultimate control in pointing out that perhaps actually condition B is all about not just management but also governance rights. That was Mr. Kirby's submission yesterday when he said, which we equated with ultimate control through their voting rights. And Mr. Valat used the phrase ultimate control today when he was talking about the hiring. So portfolio managers have a role in hiring, but the board decides. The board has ultimate control. I can't state this forcefully enough. Ultimate control is not the test. And ultimate control, concepts of control and voting power are littered throughout tax legislation. We know what those concepts look like. We know how to draft them if that is the test. Ultimate control is not the test. Voting power is not the test. What the test is significant influence. And so let's just take the example of hiring. how does the role of the portfolio manager interface with the role of the board in a hiring situation? We know from the decision that it's the portfolio managers that ultimately will choose from their pool of people, and they recommend names up to the board, and then the board has the final decision. So it isn't the case that the board is standing there with a list of every possible candidate and simply picks a candidate itself. The significant influence in relation to hiring, and obviously your human resources, your people, are a core part of a partnership's affairs, rests with the portfolio managers precisely because it is on their recommendation, be it a shortlist or an individual candidate, that they've vetted, they've looked at, they've interviewed, they've studied their CV. That's all the role of the portfolio manager. Yes, the board says ultimately yes or no to Mr. Smith, but the only reason that the board is in that position of considering Mr. Smith as opposed to Mr. Jones or other people who aren't brought to the board's attention is precisely because of the portfolio manager's significant influence in respect of that matter. That is their job. That comes from their job. It is not a test of ultimate control. So if I can just step back, I think it's fair to say that the revenues, now I'm dealing with the submissions in roughly the order that they raised. The revenues, what I've labelled common law equivalence test, has changed quite significantly from the way it was stated in their written case. And I would ask the court to go back and look at how it was put in the written case compared to how it is being put now. They're very different, and that is because in our opening, we disproved the link to common law partnership that the revenue was trying to make in writing. What the revenue are still doing, and this was part of Mr. Kirby's submission yesterday, they are still seeking to suggest that management and voting was one of the central aspects in the case law of testing whether partners were in business in common. And they are still seeking to suggest that that common law position is justification for reading condition B as including words that Parliament did not choose to use expressly. That is to say, well, we have to read influence as, or affairs, whichever word you want to read it into, as being restricted to management, governance, voting, strategy. Quite an interesting exchange in Mr. Villat's submissions. It's very hard trying to pin down exactly what they mean by all of those different concepts. And he said at one point, words to the effect of, hang on a minute, yes, it may be easier to say that test than to work it through in practice. Well, that isn't a suitable basis for imposing a statutory test that non-legal expert partners, so your small partners, your large partnerships, none of them may have legal expertise, they are tasked with applying that test. So it has to be something that isn't hard. It has to be something that is workable in practice, something that is easy to say but hard to apply. That can't have been Parliament's intention. I've already said in opening there's a real danger of being sidetracked by the particular issues raised in individual cases. So we know, for example, in Tiffin, Lord Justice Reimer was careful to say Tiffin was not representing a detailed statement of partnership law. So nothing that Mr. Kirby has said, or indeed that Mr. Villat has developed today, support the suggestion that management is one of the three central factors for determining a partnership at common law. Now, the revenue now seem to be saying that the conditions are, of course, not going to create parity with common law. But, pausing there and looking at that, if we're accepting that condition B is a higher hurdle than common law, because it's got the word significant influence, you don't find the word significant in common law, you don't find the word you have to have a significant voice in management in the common law, then why are we having a sort of double hurdle, if you like, by restricting further the range of matters over which you can consider in order to fail the significant influence test? when there's nothing on the words and there's no policy to support reading in words, because as we've already established, that isn't actually what the case law says. Mr. Kirby yesterday made a submission that one wouldn't expect Parliament to have lifted the reference to management from the default rules in the partnership or the LLP regulations. And he gave the example, well, because obviously we want to, my paraphrase, we'd obviously want to include people like sleeping partners. And he said, he then said, well, you'd obviously want to expand that to include governance, which he equated with ultimate control through their voting rights. But that's not a difficult test to formulate if that is the test you want. If that is the test you want, then the test is significant influence in taking part in, significant influence over taking part in the management, lifted from the regulations, or voting power. That's the test if that is what Parliament intended, and it doesn't say that. We don't accept the revenues reading of Steckel, but that's something that obviously the court will read in its own time. We also don't accept the revenue highlighting, for example, things like the information right and saying, oh, well, this is vastly different and this somehow matters in a material way. Because look at the relevant clause, clause 14.6. This is only the right to receive information in order to fill out your tax return. Because we say, as a result of the rights and duties overall, the portfolio managers will have access to most of the material information because of A, their consultative rights under clause 14.1, and because of B, their roles in matters such as recruitment, etc. So they're obviously going to have access as part and parcel of their other rights to information. Clause 14.8 in relation to voting rights. Again, I've already made the point, voting rights aren't determinative. You look at the cases such as Tiffin, what matters in Tiffin is also the right to attend meetings, the right to be consulted, the right to speak. Those are factors that drive significant influence. Those are rights that you have that let you influence, read purposively, the affairs of the partnership. That matters as much as voting. The corporate partner point is a red herring, because imagine for the moment a two-person partnership with partner one with 51% of the vote, partner two with 49% of the vote. Partner one can always outvote partner two. Are we seriously saying that in that scenario, partner two can never fail condition B? That can't be right. If that is the test, something has gone very wrong. Because if you take a step back and look at the nature of partnership, it is carrying on the business in common with a view to profit. Carrying on the business in common. In my 51-49% example, why on earth is partner two, with only 49%, somehow not part and parcel of carrying on the business in common?
But they'll fail the other tests if that's right.
Well,
it doesn't matter if they
may not necessarily fail the other tests.
Well, if they're carrying on the business in common.
Well, the other tests look simply at... I'm sorry, if we're talking about the other tests from a condition...
Yes. But the likelihood is that if they are really carrying on the business in common, that they'll have a share of the profits that varies by reference to the profitability of the partnership.
But with respect, in relation to the common law test, if we're looking at it through a common law lens...
No, but you're saying it can't be that condition B means what is being said by reference to the corporate partner, because if you've got two partners in the firm, one of whom's got ultimate control, but nonetheless they are partners carrying on business in common, the chances are they are going to satisfy...
Well, a couple of points. Not necessarily, and it's certainly not required that their profit share or their capital...
No, but it's going to turn into a very strange partnership if they...
Well, but remembering the artificial thresholds imposed by condition A and B.
Okay.
So in that scenario, you could have somebody that has 19% profit share and has not quite the 24% of the capital contribution.
Yeah.
and that person very firmly is carrying on a business in common. I mean, obviously now we wouldn't structure that this way because you've got the stated thresholds. But take that person who has 49% of the vote, is artificial of course, but just for the purposes of demonstrating the point, 19% profit share and 24% of the capital contributions. He's a partner through and through on the common law, but he just doesn't quite tip him over the edge. And that's why we say condition B has to look at everything in the round to work out business carrying on as the business. Just a quick note, the Revenue referred a couple of times to the non-qualifying influence that the Court of Appeal mentions, paragraph 94. That's the reference to also Mike Platt's involvement. That isn't relevant here because the first tier expressly considered Mike Platt's influence and rejected HMRC's case on the evidence. First tier, paragraphs 184 to 185, page 214. The points about horizontal versus vertical, as I think my Lord Woodbriggs said yesterday, by way of observation, condition B, of course, expressly takes into account the mutual rights duties imposed both horizontally and vertically. So nothing helps the revenue there. Moving on to mutual rights and duties as the topic. Paragraph 194, the first tier did not attach material weight to this point about the 300 million. If you look at that paragraph in the context of the decision as a whole, that is merely another way that the first tier illustrates the significance of what this 100 million capital allowance, 100 million capital allocation means. It's simply a way of illustrating.
So are you accepting if they had, that would have been an error?
If they had said, oh, well, look, this portfolio manager happened to earn 300 million, therefore necessarily because of that and that alone, of course he fails condition B, then of course that is an error, but that's not the finding. Managerial clout, the references to that, if you look at how that is referred to in the decision, that is a reference to discussions with other portfolio managers, but of course that is part and parcel of their role, to have discussions with other portfolio managers as need be. And so if their managerial clout comes from that, their managerial clout is coming from their role. And the revenue accept, importantly, that nothing that the portfolio managers actually did was either unauthorised or outside their formal role, and that is the finding. That is their written case, paragraph 49, page 186. Strategic or high-level influence, the only further point I want to make here is what the revenue are actually constructing is what I would call a mix and match test. They're having the word significant influence that condition B obviously tells us we have to apply, and they're matching in or mixing in, whichever way that works, this so-called concept from common law that you need to read in a restriction. And that's not a legitimate way of approaching the statute. Certainly not when we have already disproven that the result is something that is on a par with common law. Some of the vagueness and the difficulty in applying these terms of what is management, what is strategic, came out, I think, this morning in an exchange with my Lord Burrows. Well, what are the words that you're actually saying is the test, and how does this actually map to what's going on? And those difficulties are part of the reason we say why the revenue can't be right in their interpretation. The influence versus impact. The short point here is we don't understand the analogy between cleaners or accountants or other people who are just doing their job to our portfolio managers in this case. Portfolio managers here have a wide discretion to make investment decisions, and what we are focusing on is the breadth of their discretion. Put it another way, if you want to say it this way, what has been delegated to portfolio managers through their role is a key aspect of the affairs. So, for example, portfolio managers can enter into leverage positions. And you'll have seen from, I think it was clause 14.8, you don't have to put it to a vote in relation to borrowing that is part of the conduct of the business. That is because that has been delegated to portfolio managers, borrowing in the course of the business for so long as it is part and parcel of their formal role. So you're not going to find anywhere...
Sorry, does the FTT refer to this?
Sorry, I think that the point...
Sorry, what I understood you to be saying is that it's within the role of the portfolio managers to borrow.
Well, this is part of the portfolio managers are entering into leverage positions as well. So whenever they are taking on any sort of risk, yeah. I think that that's the limit of what I'm saying. Whenever they are taking on, yes, exactly, any sort of risk as part of their discretion, that is obviously putting the firm potentially at risk, but that has been delegated to them, not in an express clause in the LLP agreement, but as part and parcel of their role of carrying out their duties. That's the simple point. So what we're not saying is, oh, look, a cleaner must fail condition B simply because they're doing their job. You've got to understand the nature of the job. And that is where the difference, what distinguishes a portfolio manager from your cleaner, your salesperson, comes in. So just to wrap up, the meaning of affairs and over the affairs, I think the parties started to get a bit closer to where they have been previously in terms of the point of principle. If I can say this, the revenue are now saying that it has never been their case that you have to divide your affairs into 100 discrete items, and you have to have significant influence over item number 1 and item number 2, etc. We have never said, and this is the key point, that you must pass condition B as a matter of law the moment you find that you have significant influence over one thing that can be termed an affair of the partnership. That was never the way the case was put. And anything that is between those two extremes necessarily is a matter of evaluation. And so my learned friend has taken the court to, I think it was paragraph 178, 181, 194, in order to try and pluck out sentences from those paragraphs and say, oh, well, look, the tribunal made an error of law in what it said was the right test. At 178, this is page 213, the first tier's finding was that affairs of the partnership can be over an aspect. The word is can, and that is very different to saying the moment I have found significant influence over any aspect of the affairs, whatever it is, necessarily you pass.
Although that was in contradistinction to a submission that it had to be the affairs generally.
Well, and I've already said in my opening that phrase is very vague, and we don't have it in the bundle, but when you look back at all the transcripts of the hearing below, both sides, so Miss Hardy, counsel for BlueCrest, lapsed into the language of over the whole of the affairs, because ultimately that's just a labelling point. So actually both sides were using the same sort of language, albeit speaking at cross purposes as to what the substance is. The critical finding here is bearing in mind that by the time you get to paragraphs 178 and 181 of the first tier decision, the first tier has already made very extensive findings about the nature of the business. So the first tier cannot be taken as reading there, well, as a matter of course, you have influence over the investment management. Doesn't matter what that looks like in substance, therefore you must fail condition B. And the key is at 194, these portfolio managers' roles are absolutely fundamental to the core activity. That is what is underpinning the value, the fact-sensitive value judgment as to why the first tier considered that the significant influence that the members had looked at in the round, and it's not just doing deals, it's hiring, firing, counterparty relationships, etc., failed the statutory test. So you have to weigh up the relative importance of the different aspects, and that is fundamentally a job for the first tier. Unless I can assist you further, those are our submissions in the file.
Oh, thank you very much.
Thank you.
I'm most grateful to all those who have spoken, but also to all those behind the scenes who have been involved in the research, the writing, the preparation for stimulating, challenging submissions over the last day and a half, which we will go away to think about carefully before delivering our decision. Thank you very much.